Hina, you recently wrote a piece, I think on Huffington Post, about how the threats of ISIS are causing us, are requiring a need to take a look at the issue of checks and balances. Explain what it was, the point you were trying to make there, and the significance of it.
Sure. Good evening, everyone. So I had 2 points that I think are particularly relevant for our discussion tonight. One of them is that there is a failure in our system of checks and balances. It is, after all, the power and obligation of Congress under our Constitution to declare war. And instead, we've had so far the executive branch taking us into war on a claim of legal authority that is quite simply untenable. So failure of checks and balances, we'll come back to that. But one of the reasons that I think it is so important for Congress to declare war, to decide with specificity who our enemies are, and purpose of the war into which we have been launched, is because for over a decade, the executive branch has made claims of war-based authority to enact and carry out policies that go beyond what is permissible under international law, under our Constitution, violating human rights, individual liberties, and they've done that under a claimed veil of secrecy. So let's talk then about secrecy, right? The subject of our panel discussion tonight, and I would venture to say that there might be agreement on a couple of different points this evening. One is that it is certainly the case that certain information can legitimately be kept secret by the government. It's also certainly the case that the press, under our Constitution, under the First Amendment, plays a very important, sometimes necessarily adversarial role. But I think that the debate now is really over 2 main things. One, whether the executive branch has a monopoly on secrets and what can be made public. And 2, when there are unauthorized disclosures, often of information that the executive branch has deemed classified, then the question is, what happens? What are the consequences? And here I think it's useful to go back to one of the great statesmen and scholars of secrecy, Senator Daniel Patrick Moynihan. And he wrote in his seminal work on secrecy that secrecy is a form of government regulation. And that is, in fact, legitimate at various times. When we're talking about foreign policy and war power, secrecy, in essence, becomes what the government thinks the American public can and should know. And Senator Moynihan talked about the ways in which secrecy can undermine what the executive branch does by preventing the branch itself from correcting mistakes. And I think the paradigmatic example of that in the last decade or so is the fact that we went to war in Iraq on trumped up bogus evidence. But then there are other ways in which secrecy plays out. Some of them are to hide from the public transgressions of the executive branch. And so think back to some of the things that the executive branch said it did and did not do. Highest levels of the Bush administration, we do not torture. Of course, as a result of unauthorized disclosures, we came to find that, in fact, we did torture. We tortured at Abu Ghraib. We tortured in Afghanistan. The CIA launched a massive program of extraordinary rendition and torture. These unauthorized disclosures made public in large part by the press, alongside the disclosures starting in 2005 onwards that the executive branch had been engaged in violation of the FISA, the Foreign Intelligence Surveillance Act, and engaged in a massive program of surveillance of Americans. And one of the final insights that I put to you that Senator Moynihan had is that when we engage in secrecy as this form of regulation, the executive branch often uses secrecy as a means of creating the outsider, stigmatizing critics, which is one of the things that I think reveals itself in a phenomenon that goes on all the time. That is the phenomenon of favored leaks and disfavored leaks. In the last 10 plus years, we've seen a repeated pattern of favored leaks that are leaks that the executive branch says show that the programs it's engaged in are lawful, effective, wise. Disfavored leaks are the ones that call those claims into question. And we have, as CIA General Counsel once told the Congress in testimony in 1979, we have a regime in which, since 1917, we've had a statute that criminalizes the gathering, dissemination, retention of certain national defense information. And the CIA General Counsel said to Congress at the time that we have a virtual crime wave going on every single day because of the disclosures that are taking place that are authorized or unauthorized, but never actually get prosecuted. And now, under the Obama administration, we've had a massive increase in the numbers of prosecutions of people who have disclosed information, unauthorized disclosures. And so that calls into question now, the second part of what I expect we will discuss, is what are the consequences and what are the system we're living in, and is this tenable in a democratic society?
Let me pick up on that great overview with just the first point you raised about legal authority to go to war, because the White House has said it has all the legal authority it needs to wage the campaign that it has proposed against ISIS, yet it has not released its legal analysis. Bob Deitz, does the public deserve to see the legal analysis upon which the president is taking us into a new military campaign?
Yeah, I think as a general principle, yes. But let me start out
by saying... So you would quarrel with the White House's refusal to release its legal authority?
Look, as a trained lawyer, I'm used to pushing back on misstatements, mischaracterizations of what I said. I said as a general rule, correct.
But in this case, we don't.
I don't know. I mean, one of the things about Anglo-American legal system is that good legal opinions are interwoven heavily with facts. In other words, if you simply look at the legal opinion, the legal reasoning itself with nothing else, no other context, it's often very hard to determine what's going on. The facts may well be classified. I don't know. I also want to go on and say I'm not here to defend every president who's ever, lived, nor every decision by every president. But so the answer is, could be. I think it's useful. I do take serious issue with the notion that all of this has been done lawlessly. The Congress passed the authorization for the use of military force, the AUMF, following 9/11, and that was the authority of the Bush administration to conduct war. Now, the terminology didn't say war, but the Supreme Court has held repeatedly that there are no magic words that have to be used in order for Congress to say, go ahead.
But the authorization to use military force passed after 9/11 was targeting the people who engaged in 9/11 and associated forces.
Agreed.
ISIS didn't exist at the
Agreed.
time, and the administration is saying that same authorization covers what they want to do now. Gabe Schoenfeld, is the legal analysis upon which we are now preparing to go to war a necessary secret?
I think as a general matter as well, that it's bad to have secret law, and the government should, to the maximum extent, declassify legal decisions without disclosing the facts that compromise ongoing operations, military operations, intelligence operations. Maybe there's a tension there in this document. I don't know. I am actually suspicious of the Obama administration. I think they have, in some instances, gone too far in the area of secrecy, and I say that as a defender generally of secrecy. I think they may have been overstepped.
In what way?
Well, in some of the things, the other things that I think perhaps talk about today, their very aggressive campaign against leakers has taken some steps that I think, while I think is a good thing overall, it's taken some steps that I think step too far. For example, charging Bradley Manning with a capital offense of aiding the enemy. That in effect makes leaking, of course it was under the Uniform Code of Military Justice, but it makes leaking a capital offense, which is a radical step and unnecessary. He was acquitted on that charge, fortunately.
So you think they're overcharging?
Yeah, so I think they've pushed a bit too hard. The Drake case, that a couple of their cases have fallen apart. Thomas Drake was prosecuted for over a period of years for providing secrets to the Baltimore Sun reporter. Bob might know more about this, but the case in the end fell apart, and it seemed they didn't have all that much.
Well, I want to come back to these cases, but just to finish up on the current ISIS point and the legal authority question, Bob, you said that facts matter, and therefore it may be that they shouldn't release the legal analysis because it depends on the facts. But don't the facts also matter for the American public to make a judgment on the wisdom of what the president is proposing? Bart?
I would certainly agree with that. Look, I'm not a lawyer and I don't play one on
television,
live webcast. But as a general observation, it's typical of legal briefs and legal decisions that you have a section on the facts and a section on the law. The legal analysis certainly is entwined with the facts, but if you are concerned about trying to allow yourself to be held accountable, you can easily write a brief or an OLC opinion in such a way that you are referring to a classified appendix. It's impossible to believe that the thing has to be classified in its entirety and not redacted if there are important factual things to redact. And so when you have the government saying, we assert a power, which is among the gravest and most consequential powers a president can exercise, and we won't tell you why we think it's legal. That's an extraordinary thing to do in a self-governing state, and it ought to be done only in the most extraordinary circumstances and with the most extraordinary efforts to disclose as much as possible. And that sort of self-evidently has not happened here.
Yeah, and I'll just add as a footnote to that, I actually asked a very simple question of the White House the other day. Is there an OLC opinion on the president's invocation of the authorization to use military force in the campaign against ISIS? And the response was, as you know, we don't discuss OLC opinions. Now, if this is the legal analysis upon which the president is going to war, and Bob Deitz, you just said, as a general principle, these ought to be made public, then what do you make of an answer from the White House like that?
I wouldn't be particularly satisfied with it.
And you're speaking not as a journalist here, because you're not,
No,
but as a former senior lawyer in the
Yeah, and I think obviously
NSA.
you want, in a nation of laws, you want people to understand the law. And one of the ways people can learn and understand the law is through the release of opinions. Now again, I'm not privy to whatever it is has caused the White House to do what it's done. But I certainly agree, and by the way, Bart's perfectly right. You can redact opinions and get problematic facts out of there.
I'm putting that on my business card.
What, that I once agreed with you? Yeah. But no, absolutely, as a general rule in a democratic society, these kinds of things ought to be, people ought to know what the law is.
But there is a long tradition of keeping OLC opinions secret. In fact, a huge trove of them was only, going back all the way to World War II, was only declassified earlier this year. So I don't think what the Obama administration's done here is entirely novel, but maybe unnecessary. I'm not.
But that's part of the problem, because part of the problem, especially since 9/11, is the OLC, as many of you know, serves as the final sort of point of authority within the executive branch on how the executive branch interprets the law. And for very important reasons, we question and largely reject secret law. And so when we don't actually have the executive branch's interpretation of how it applies the law, then that's deeply problematic. And it's problematic also because facts matter. And facts matter because it's not just because we apply law to facts, but look at what's happened in the last 10 years. So Mike, you know, the 2001 AUMF nowhere mentions associated forces. It talks about individuals, organizations such who are responsible for the 9/11 attacks. In the last decade plus, our nation has been carrying out secret and semi-secret paramilitary activities in an unknown number of countries around the world in against at least only one organization that the administration has finally under pressure disclosed. And it is only as a result of years-long litigation that we have started to get the legal analysis that forms the basis for this broad, vast lethal force program, a program that has been carried out against people, including American citizens, and we don't know the fundamental facts of who we are killing, why, with what consequences, how many of them are wrongly targeted, and we don't therefore have a public debate about the costs and consequences, or as meaningful a debate as we could have, about these claims to war-based authority, which many military leaders tell us is creating more enemies than it has killed.
In particular, I want to ask you about Mike Hayden's comment. We don't have the legal authorities to do anything beyond what we're doing. You were the general counsel for the NSA. And as I recall from the NSA Inspector General report, what was then directed by the White House for your agency to do under a new legal regime was so secret that they wouldn't even share it with you, the general counsel of the NSA.
Yeah, I wouldn't say they. I would say David Addington.
Well, he was the chief counsel for the vice president who was directing the policy.
Right, but as big as he is, he's still only one person.
But he had the authority to keep it from you.
He did keep it from me.
Yes.
So the question I had, and reason I was asked by General Hayden about my views was, the reason was, did I believe it was lawful? I wanted to know what the OLC had said to see, in large measure, whether they and I were working under the same legal theory. We weren't.
So you believed what they were doing was unlawful?
No, I believe what was done was lawful. I had a very different legal theory from OLC's. And to this day, I prefer mine, but that's a different story.
How do you even know that? Since the crucial moment was when your deputy and the acting general counsel, Vito Potenza, and Joel Brenner, who was the IG of the NSA, went to the Justice Department for a meeting with the Office of Legal Counsel and said, we'd actually like to read why you think this thing we've been doing for the past several years, is legal. And David Addington, the vice president's representative, came to the meeting unexpected and frankly uninvited and told them to go home, that they were not going to be allowed to read the Justice Department opinion. So how did you ever read
I wasn't there for that event, so I can't answer that. I've since seen the opinion, is my point.
Right, well, you may have seen it back sort of, 5, 6, 7 years later when the IG was, right.
Correct.
You saw it.
But fundamentally, that doesn't matter, because I was asked by my boss, do you believe this is lawful? And I had spent a sleepless night or so thinking about it and decided that it was. I wanted to know what the OLC opinion was more out of curiosity. And I got back to Hayden and said, I think this is lawful. I believe, actually, if it went to the Supremes, you're never going to predict what they do. But I said, I think on balance, we've got a very strong case, and I think we would prevail.
Well, let's talk about the subject of judicial review of these very issues.
Can I just actually add one more thing
please
that's
do.
completely pertinent to this?
Yes.
First of all, in 2004, the Office of Legal Counsel, which is the authoritative arm of the executive branch on what is lawful and what's not, across the board, changed its mind and decided that portions of this program, which was called, its cover name was Stellar Wind, was unlawful. And number two, when General Hayden, who was then head of the NSA, was notified about that, Addington called and asked him, what are you going to do? Are you going to keep doing it or not? And Hayden says, I'm going to keep doing it. And he's acknowledged that with me. And number three, we only know all of this because of Edward Snowden, because the 2009 Inspector General's report, which we're talking about up here, was among the documents that he leaked to me and two other journalists.
I don't think that's correct. I believe that again, I was seconded down to DOD at that point, but my understanding is that the program that Jack Goldsmith had concerns about was shut down immediately, And then later on, Jack worked out other ways of skinning that cat.
I'll let the two of you work.
I recommend a book called Angler.
Let the two of you work this out later.
It's more fun being there.
To Bob's point that, well, I looked at it and concluded it was legal, maybe under a different theory, but it was lawful. Is that okay? Is that enough for a general counsel at the NSA or the CIA or somewhere in the government
As compared to what?
Well, I'm asking Hina the question, and then you can respond.
Right, and this goes back to our question of checks and balances, secret legal arguments, reinterpretations of the law. Now, one of the things that, well, I'll let Bob speak for himself, but one of the issues that comes out often with respect to Edward Snowden's disclosures, including disclosures of the IG report and other, underpinnings of this surveillance program, is the argument that all three branches of government signed off, right? But you look at which branches of government signed off and what was actually going on. So with respect to judicial review, the only meaningful or only judicial review was done, but was by the Foreign Intelligence Surveillance Court. This is a court that was originally set up to have something of a limited purpose, right? This is a court composed of Article 3 judges that does not have an adversarial process. The executive branch puts on its case. The court does its best to figure out, whether this is lawful, is not lawful. But essentially, what was a court set up to review warrants to engage in surveillance turned into a court that used and reinterpreted facts and law, creating secret legal interpretations that resulted in and contributed to a massive surveillance program in which Americans' metadata and other kinds of extremely revealing information was now being gathered by the executive branch unknown to us Americans. And when there were actual challenges brought in federal court, where you can have an adversarial process, a challenge brought by the ACLU, the government's answer was that we didn't have standing. We didn't have the ability to be able to say that our information was being surveilled, that it was entirely speculative for us to do that. And the executive branch said that, in fact, the best way for these kinds of programs to be challenged was through notice that would be given to criminal defendants against whom these programs were used. Well, lo and behold, Snowden disclosures come out, and it turns out that our communications, along with yours, metadata, were being swept up and kept. And now, of course, we do have the kind of standing that allows us to bring a challenge on the substance of what the program is, the constitutionality of that program. And we can talk about this a little bit more, but I think it's really important to point out the importance of checks and balances judicial review in this process. FISC, no adversarial process, doesn't really have the technological capacity and know-how sometimes to know what it's actually reviewing. As one judge said to the government in an opinion that's since become known, we're relying entirely on you for your representations. And even in those early years, we come to find out, there were multiple misrepresentations made to the FISC by the executive branch about the ways in which information was being gathered and ways protections were not being complied with.
Let me stop you there. Gabe Schoenfeld, if that's the case, and I think the record would strongly support it, doesn't the public deserve to know the misrepresentations that the government makes to a court?
Look, the country was attacked on September 11th. That is what this discussion should be about. The British subway, the London subway system was attacked. The Madrid subway system was attacked. There are people out there who are trying to kill New Yorkers, kill Americans. We have a large national security operation apparatus that is working tirelessly to stop this from happening. I think many of the problems that you point to are real, but they are often a necessary accompaniment of the massive effort we need to do to stop terrorism. I think the ACLU does a good thing by challenging the government and forcing it to defend its practices. But I think there's a danger that all the energy going into exposing the wrongdoings, the shortcomings, is forcing this intelligence apparatus to focus not on stopping terrorism, but on just justifying its own practices. I think that's very dangerous. I think we are setting ourselves up for an attack.
I would add that we were attacked on Pearl Harbor as well, but that didn't make the internment of Japanese Americans okay or constitutional.
I fully agree with that.
Wait a minute. What do you mean? It was adjudicated that way.
It was adjudicated. Did it make it acceptable? I mean, didn't the U.S. government finally
either
apologize?
we're talking about law or not.
Mike.
Well, we're talking
there
about
was an
policy and
adjudication
law.
by the Supreme Court. Now, in retrospect, one can say we shouldn't have done that. Fair enough. But let's
fair enough.
Let's not
that's
say
a rather huge point, isn't it?
Let's not say it was unlawful.
I think
And things that were done that were unlawful,
Right.
everyone celebrates today.
Right.
Like bases for destroyers.
Okay.
So when we start out by defending government action, by defending Japanese internment, I think we have a little bit of a problem. But let me just respond to Gabe more directly, which is that no one denies that terrorism is a threat. No one denies that the intelligence agencies have a very important function to fulfill. That's not what the debate is. The debate is about what happens when the intelligence agencies violate the law and lie about it, and that has significant consequences for not just our system of checks and balances, but also for individual rights and human rights and civil liberties. That's what the conversation is.
Can I respond? There have been a lot of allegations.
Briefly, because we got some other things to cover.
Sure.
Yeah.
A statement that the intelligence community violating the law, I don't believe that's true. I don't think there's any evidence of it. With respect to the checks and balances, I agree. I never feared having that special NSA program adjudicated. Never at all. I was perfectly prepared to make the argument. Whether it would have prevailed or not in the Supremes, who knows? But I certainly never feared it.
Did you fear it being publicly exposed and the public learning about what the NSA was doing?
I personally know, but the operators certainly were. Absolutely. You cannot have a transparent intelligence agency.
No. So actually, my question is very specific. In all the meetings you were in, when the government was beginning bulk collections, massive collections of Americans' phone calls, records, metadata,
okay.
yes, records. Was there ever a instance where you remember somebody said, wow, if the public ever learns about this or the Congress ever learns about this, we could be in big trouble?
First of all, Congress...
You ever remember a conversation along those lines?
Congress was aware of it. Congress was aware of it.
It's now, both houses have now passed legislation to end the program.
Yes, but so what?
So what? They learned about it thanks to the reporting?
Congress was told about it. Later, a law was passed allowing it. Now, retrospectively, they're saying maybe that wasn't such a good idea. But the fact was, it was a lawful program. Now, you can cavil about the notion of collecting lots of metadata, and I understand why some people would. But let's not discount the potential value of it.
Can I respond to that, actually, Mike?
Let's make the direct case for secrecy. There are many things that the government is doing which we can't disclose because to disclose them informs our adversaries about them.
Okay, I have a question for Bart on that very point. Just in the last couple of weeks, I want to read you a couple of statements from the heads of our national security agencies about the impact of the Edward Snowden disclosures. Admiral Mike Rogers, the director of NSA, last week, there should be no doubt in anyone's mind that I am watching groups change their behavior as a direct result of these revelations, groups that represent a direct threat to the citizens of this nation. The same panel, CIA Director John Brennan said the Snowden leaks have had a devastating impact on intelligence collection. And Matt Olson, the director of the National Counterterrorism Center, in a recent speech at Brookings said, Quote, following the disclosure of the stolen NSA documents, terrorists are changing how they communicate to avoid surveillance. They are moving to more secure communications platforms, using encryption, and avoiding electronic communications altogether. This is a problem for us in many areas where we have limited human collection and depend on intercepted communications to identify and disrupt plots. Do you, Bart, have any reason to believe that what Rogers, Brennan, and Matt Olson are saying is not true? And if it is, would it have changed your calculus on what you published and how much you published?
So I'm going to answer that directly, but first I'm going to say something a little bit broader. I'm going to try to take this up to a little bit higher altitude. The whole subject of this discussion tonight is about trade-offs. It's about two very fundamental values that we hold. One is to protect ourselves, self-protection, and one is self-government. And it is not often easy to find people who are willing to take both sides of that equation seriously. That is, say, if you think both of those are really fundamental, and clearly the framers of our Constitution did, there were 6 fundamental values that were outlined in the preamble of the Constitution, and it began with "we the people." The national defense, the common defense, was one of those 6. It's not our only, it's not even our preeminent value. It's among several very important values that we hold to. And so, in principle, I'm prepared to accept that there could be some damage, sometimes, certainly some disadvantage to a conception of national defense or how we protect ourselves at an ultimate level by allowing the public at large to talk about it. The Espionage Act appears to forbid the discussion of anything relating to the common defense. So an Army division typically consists of 3 operating brigades and a headquarters brigade with the following elements in it. That's public. Or the NSA devotes 20 to 25% of its financial resources and personnel to counterterrorism, but most of what it does is not about terrorism at all. That's actually classified. Can we have a perfect world? There's a story I like to tell. I was a tourist in Moscow back when there was a Soviet Union, and I kept getting lost, and I don't usually need a lot of help with that, but it turned out I did have help with that because the Soviet tourist maps were deliberately inaccurate, because that's information that in principle could be useful to the enemy. If Napoleon comes back and can't find the Battle of Borodino, then he's going to lose. So the idea that our only consideration here is damage, I would reject. I also reject the idea that secrecy and security always coincide. Certainly they do sometimes. It's no doubt about it. Because some things have to be secret.
But just to be clear, what they were saying was not some theoretical damage. What Admiral Rogers was saying is that I am watching groups change their behavior as a result of these
previously he said the sky is not falling, and he's not saying that there's been devastating harms. The DNI, Clapper has said behind closed doors, though not in public, that when you lose one channel, you find another, that people will have to communicate, they will make mistakes, and we will exploit them. That's his quote. All that being said, I'm sure that there are some losses. You would have losses if we went from a system in which a wallet goes missing in this room, and the rule says you could shake out everybody's pockets, to a system in which you have to have probable cause to search somebody. That's a trade-off that we willingly make, we accept. And what we have here is a system in which there were boundaries being drawn about what secret intelligence could do in a democratic society that the public did not know anything about. And although in a formalistic sense, there were some, not anything close to a majority of members of Congress who actually knew what was being done, it should be instructive that after the disclosures are made, Congress is passing new laws. Courts are, for the first time, hearing arguments on the merits of these programs, and they're now split on the constitutionality of one of them. Silicon Valley and the market for communication services in general has transformed itself in response to what it takes to be customer demand for more security. And the largest U.S. internet companies are now, this is kind of an amazing thing to contemplate, they are now deliberately taking multi-billion-dollar steps to thwart the intelligence collection of their own government against their users, because they insist that they will not give up information outside lawful process of which they are aware.
As I mentioned when we started off with that original video montage, these are not new issues. And we actually have another absolutely fascinating clip from a movie about events that took place during the Nixon era. And that was the theft of FBI documents from an FBI office in Media, Pennsylvania. First published in the Washington Post in 1971. These documents are, thanks to, as a result of these documents, the public learned for the first time about a secret FBI program called COINTELPRO, which was a massive campaign by J. Edgar Hoover to discredit political dissidents and civil rights leaders. We have Betty Metzger, who first got the stolen FBI documents at issue here, then with the Washington Post, more recently the author of a fabulous book called The Burglary, and Joanna Hamilton, who made this great documentary. Gabe Schoenfeld, was it a good thing that those burglars broke into the FBI office and exposed this massive illegal program by the FBI?
So there are possibilities when you have good outcomes from bad deeds. This may well be one of them, but you can't have a system of government where private citizens break into government offices, steal government documents, and then decision-making is made in that manner. As a general proposition, that would lead to the complete destruction of our democracy. But could there be cases where it works out to the country's advantage? Absolutely.
But I think the point is that when we entrust government agencies with huge powers to conduct operations in secret, there are very often abuses that the public deserves to know about. Bob Deitz, do you agree?
Of course I agree. What always bothers me about panels like this, and I've served on a number of them, is that inevitably they bring out the Nixon years. Which is simply false. NSA,
What's simply false?
The analogy.
Okay.
The NSA is probably the most highly overseen agency in our government. And I say that with great confidence. There are endless reports that are filed in the executive branch to the Department of Justice. There are IGs, of course, in NSA, but also DOD. There are reports to Congress, and you've got the FISC. I don't minimize it the way some people do. These are Article III judges. These have been, confirmed and so forth by the Congress. So there is simply no way that NSA can run amok in the way that that some of these agencies did run amok during the Nixon administration.
Then, Bart, go ahead.
I might surprise you by starting off by agreeing with a chunk of that.
Do I steal my wallet?
It's on tape. And this is why I also liked your point, interestingly enough, about Korematsu against the United States and the Japanese internment, which is that the important things that need disclosure are not always about abuse or about violations of law as the government then interprets them, the law. So, for example, 2006, a reserve unit comes home and starts telling a reporter from Minneapolis Star-Tribune that they're getting badly hurt because, despite many years of promises, the Humvees they're using in Iraq are not getting extra armor. And USA Today also picks up the story. That fact is classified. The information in those stories, some of it is classified, having to do with procurement of defense systems. But it's published, and the Defense Department is embarrassed, and Congress says, wait, you're not protecting our guys. And they order the Inspector General of the Defense Department to do a report, which eventually concludes the following year that there was $2 billion sole source contract being awarded to a company that was not performing, despite the fact that the contract awarder knew there were alternative sources. And so what protected security of American troops? Was it secrecy or was it disclosure? Because in fact, they got their armor. And so a lot of times big, important public policy questions or even national security questions are raised that don't talk about illegal activity like, I don't know, Abu Ghraib, or like human experimentation after World War II with deliberately infecting people with syphilis or exposing them to nuclear radiation, both of which also classified to prevent the public from finding out about them. And so I believe that the NSA actually does have a very strong compliance culture as a rule. And also, these things we've been talking about and the Snowden revelations are not sort of the NSA acting on its own. It's the NSA acting at the behest of the executive branch and ultimately of the president. But this whole compliance apparatus is designed to ensure that the actions fit within whatever extraordinarily expansive interpretation of the law and the rules the executive branch has at any given moment. And that might not be recognizable. And I won't filibuster here, but one last thing here. Section 215 of the Patriot Act, which allowed the call records program that's become the most debated part of the Snowden disclosures, was not obscure. It was very aggressively debated at the time it was passed and at the time of renewal. And in order to reassure the American public that this was being used narrowly and proportionately, the FBI, the Justice Department, began putting out statistics. At first it said that even saying the number of times we use this provision would be a grave threat to national security and is classified, but then it agreed to put out the numbers. And so in 2009 it said 29 times. We've only used Section 215 29 times the entire year. You don't have to worry about us running amok with this thing. It turned out that with 29, with 12 of those 29, they could get 1 trillion call records. And ordinarily, when that's an actual number. I mean, it's the closest estimate of the number of call records in a given year that you got from this metadata program.
Mike, can I add?
Sorry. You know, ordinarily, if someone tells you 29 and they mean 1 trillion, you're going to feel misled. And that's the problem with things, even if they are lawful, as the executive branch understands it.
I want to get a response from Gabe, but Hina, go ahead briefly.
I think there's a direct line to be drawn between what happened in Media, Pennsylvania to Snowden, and this is how it goes, which is that as a result of those burglars, as a result of COINTELPRO becoming something known that ends up being sought through the Freedom of Information Act, we end up having the Church Committee and a set of reforms for the intelligence community that come out of the Church Committee. And I'm grossly oversimplifying, so I'm sure I'll hear about it. But one of the bargains that was struck post-Church Committee reforms was that in exchange for greater secrecy, we would have greater oversight by Congress and the executive branch. And I think what Snowden showed is how that bargain broke down. That while secrecy increased, oversight broke down in itself. And I think the most significant way that you can tell that is that once the Snowden disclosures became public, every single branch of government radically changed course. All of a sudden, the executive branch welcomed debate that it had essentially shut off by holding things secret. All of a sudden, Congress said, many people said, we didn't know about this, we didn't authorize this, and now there's actual meaningful reform that would put an end to the bulk surveillance program. All of a sudden, the courts are actually reviewing the constitutionality of the program. We've got decisions going different ways, but the branches of government have changed direction. I think that's one of the most significant consequences post-Church and post-Snowden disclosures.
Gabe, isn't this a vivid example of the dangers of secrecy? When people like Bob and his colleagues make decisions in secret, they miss big pieces of the debate. They don't understand how it might affect and be viewed by the public and others.
I don't think there are anyone here who doesn't recognize the dangers of secrecy. That secrecy can be a cover for all sorts of abuses of many of the kinds you've enumerated. However, any country, and particularly any democracy, trying to conduct a policy is going to have to do certain things in secret. And we have a representative government. Oversight is critical. If it's not working, it needs to be fixed. I don't believe it should be fixed as the result of grossly illegal actions by somebody who's not even properly committing civil disobedience. It's civil disobedience light, where you break the law but don't accept the consequences, and that's something like what happened in Pennsylvania. It's not true civil disobedience. If Snowden had taken his revelations to the Supreme Court steps and revealed these programs, I think he'd be treated very differently than a man who's fled to Moscow and is lecturing America on surveillance from a surveillance state. I think it's very troubling.
Bob, is Edward Snowden a whistleblower?
Depends whom you ask.
I asked you.
And I will give you the answer. One man's whistleblower is another man's malcontented employee. One of the problems, and we saw this with an earlier leak of an NSA thing program, is that a person will catch an aspect of it, understand an aspect of it, and it's clear that something, my God, this must be illegal, without understanding the entire context. Snowden had all kinds of outlets to raise issues of legality. At least 6, or probably more, but certainly 6 he could have used. He chose not to. I believe that he is a person who was seeking fame. There's a huge sanctimony quotient, to my mind, in this. We are representative government. We have overseers. We have ways of addressing these kinds of issues. Taking the law into your own hands, to my mind, is simply not the right way to go about it. There's a quote that plenty of reporters use that we saw it in an earlier clip. It's the government's job to keep secrets. It's our job to ferret them out. It's a bank's job to keep your money, but it's a burglar's job to break it out. I mean, what this is, to my mind, is an absolutely lawless notion about how democratic governments operate.
Okay, I had a philosophy professor in freshman year who asked me, "Are you persuaded by that analogy?" And it was a fairly embarrassing question because when I stopped and thought about it, I wasn't. So bank robbers. Now the issue here, if you take seriously the idea that we have 2 vital interests at stake, self-government and self-defense, then that entails that you cannot have a system in which the president gets to decide under all circumstances what facts may be secret and which may not. Now, it's his primary duty. There is a national security secrecy system, and the presumption should be that we've elected a president to make judgment calls like that. But let me just ask you as a hypothetical, okay? In the 1950s, the U.S. government was deliberately injecting servicemen with syphilis and deliberately exposing them to radiation. So just, and I'm not saying anything like that's happening with the NSA, but just as a matter of principle, would you have felt, if you were in a small group of people who knew that was happening, that it could be justified?
Yeah, I think so.
To leak it.
Well, you think what?
That it would be justified.
You
Yeah,
would have leaked.
And so
I probably would have.
And so the question now is
committed
just,
an unauthorized disclosure of classified information.
Absolutely, but I wouldn't be in Moscow.
Gabe, would you?
Well, let me ask
Would
Bart another question. A very hotly debated question inside the U.S. government not long ago was whether to launch a raid to capture or kill Osama bin Laden. There were people who disagreed with the decision. It violated Pakistani sovereignty. If one of those people had decided to leak it, would that be justified?
I'm not defending all leaks or all leakers.
But the principle is the same. If someone
feels
chooses
strongly.
strongly, do they have the right?
No. I wasn't advancing a principle yet.
Okay.
Actually, what I was testing is whether, as the expression goes, what's your price? I mean, once you acknowledge that there are circumstances, then we're open to debate, and then all the absolutist nonsense about how you swear an oath and you must never disclose a secret no matter what isn't there.
Well, no one subscribes to that absolutist. No one here subscribes to that absolutist position.
So then where we should be arguing here is about what kind of factors would make And let's talk about from the point of view of the media, because let's face it here. I am ultimately the one who disclosed the classified secrets when I wrote about them in the Washington Post. And you've written that reporters should be regarded as engaging in active civil disobedience in those cases and be subject to prosecution.
Well, fortunately, we've never had a prosecution in this country because we've never had a press that inflicted that kind of damage on the country, although we came close during World War II with the Chicago Tribune case. I know in your case, Bart, that you have checked with the U.S. government before you publish things and get their opinion and make careful decisions about the impact of your stories on national security. But not every journalist is a Bart Gellman.
So
I mean, and the
Well,
press.
I can certainly agree with that.
And the press is no longer the press we had a decade or two ago. We have a foreign press which has the same rights as American correspondents to report. We have Al Jazeera reporting. Can they ferret out secrets from the U.S. government?
The real point of inflection is not a decade or two ago. The real point of inflection begins in 1971. It begins with the Church Committee. It begins with the Vietnam War. It begins with Watergate, and the loss of the presumption that we should trust the government in a blanket sort of way to exercise its power properly or lawfully. And so you have the beginnings of an adversarial press. And I am not taking the position that anything we've seen in the NSA papers so far is, on its face, obviously unlawful. There are legitimate legal questions about some of them.
On the issue of Snowden, I have a question for you because you've probably spent as much time as any journalist with Snowden. There's still a lot of questions about what he did, how exactly he did it, why he did it, and what he has said about it. And I want to give you one example that's come up recently. In his NBC News interview last May, he was asked the very question Bob was saying he should have done about going through channels. And he said this: "I actually did go through channels, and that is documented. The NSA has records. They have copies of emails right now to their Office of General Counsel, to their oversight and compliance folks, from me raising concerns about the NSA's interpretations of it, legal authorities. Now, I raised these complaints, not just officially in writing, through email to these offices." The day after that interview, the NSA released the email, one email that said it could find, to the General Counsel's office. It actually didn't raise any concerns. It was a rather narrow legal question about what the authorities were. And he was invited, if he had any further questions, to write back. More recently, in litigation for any other emails or records the NSA might have, the NSA's Associate Director for Policy, Dave Sherman, filed an affidavit just last week which has said the NSA had launched a comprehensive investigation for all emails from Snowden that might have raised concerns. Said it checked his inbox, anybody who he worked for, all NSA email accounts, and it could find absolutely nothing, no other records of Snowden raising any concerns. Does this give you any concern yourself about the truthfulness of what he has said?
I have very, very seldom in my career, and I'll back up and say that I have had lots of really great sources, whether they were senior government officials or low-level people or people outside the government, who were wrong about lots of things or even tried to mislead me about some things and still were very valuable sources, because I don't care whether someone has good character or good motives or is always right. I care about whether I learned something that I can verify and that matters. Snowden is among the very most reliable sources I've ever had in terms of when I ask him a factual question and he gives me an answer. I have yet been able to demonstrate to myself that his answer was false.
So what do you make of the very issue that I raised?
I'm getting there, but because I want to make sure that we got the foundation for this. There are two things about whether he made the complaints internally. One is, you could imagine 3, 4, 5 different explanations for why he would say what he said on NBC, and the NSA would say it can't find any record of that. It ranges all the way from he's wrong, to he's lying on one side, to the NSA is lying on the other, to it being actually true, what the NSA initially said, which is that it doesn't have any way of searching its entire database for a single correspondent, to it made a mistake. I mean, the government agencies have been known to lose emails. But here's the fundamental point: is did he bring his concerns to the attention of colleagues and supervisors? He says he has. He's told me quite specifically the positions of those people. I've asked the NSA repeatedly in writing over several months, can you tell me, have you interviewed all the people in these positions, and have they told you that he never said anything of the kind to them? And the NSA will not answer that question.
Does it strike you as at all odd that he was able to download hundreds, tens of thousands, maybe hundreds of thousands of classified government documents and give them to you and Glenn Greenwald, but he somehow didn't keep a copy of any of his email expressions of concerns about these policies?
I'm sure he wishes he had.
I'll bet.
How do you explain the fact that he didn't?
Look, he did not want or expect this story to be about him. He was actually trying to expose information he thought the American public needed to know about what its government was doing. And while it's a valid question, and I'm happy to answer questions about whether you want to hold Snowden accountable or whether you want to make a judgment about his character, I personally think a more interesting question is holding the government accountable for its use of its enormous power. All that said, he didn't think that he was going to be in a position where he was sending out stuff, opening up the door to his email accounts. He was looking for policy and operational documents that illustrated the problems he saw.
Michael, let me just say that,
Yes.
when I was general counsel, and I know that my two successors well, we always addressed those kinds of issues because we were always concerned about somebody believing that a program was unlawful, and therefore we wanted to make sure that that person was satisfied. So I am extraordinarily skeptical.
Let me just add a couple of thoughts on that. One is, and I've no special knowledge of this from Mr. Snowden, but think about what Bob has said earlier on this evening, which is that all three branches of government had signed off on the program that Mr. Snowden thought was unlawful. So one would wonder why he would go to the executive branch, which thought it was completely lawful, to say, I think it's unlawful, why he would necessarily go to Congress, which had signed off, to say, I think this is unlawful, or the judiciary, which, quite frankly, the idea of standing on the Supreme Court steps to waive classified information raises concerns that I'm sure you would have. But I think the more fundamental point is that what Edward Snowden did was give information to the press, gave it to journalists who made the decision about what to publish and what not to publish, and who often did that in consultation with the government. And I think a final point, and one of principle, is really, let's step back from Mr. Snowden. Let's talk about a little bit what the regime right now is with respect to leaks of information. It is virtually a strict liability regime. It does not take into account whether information that has been leaked is about unlawful, abusive, illegal government conduct, whether the information that has been leaked is in the public interest and how it must be balanced against national security. And the consequences have been, as you see in Chelsea Manning's case, really dire. And I think one story really brings this home. This is a story that Daniel Ellsberg tells about his trial, when what he wanted to do was talk about why he had wanted to publish the Pentagon Papers, and was in consultation with his lawyers about this, and they said, you'll get a chance to talk about that at trial. You'll be able to talk about why what you are doing is in the public interest and beneficial to the government. So trial happens, and the lawyer says, Mr. Ellsberg would like to be able to testify about his disclosures, and the government said objection, and the judge said sustained, which meant that it didn't happen. So, we don't really have a regime that allows us to take into account principled leaks with ways in which we can look at what the consequences will be And until that happens, that's the kind of debate that we actually ought to be having with respect to consequences.
Think about the consequences of what is being proposed here. Any civil servant in a government that has millions of civil servants who have possession of classified information could have some principled objection to some government program that they don't agree with, and they could end it. We would have Socrates. The government would be paralyzed. There would be no possibility of democratic government with that kind of regime.
I think there are a lot of people in our audience that I think have some questions here, and I want to start out with Joel Simon, who had a question, I think, on the Obama and press freedom point that Hina was raising.
Yeah, I mean, I think I just want to broaden this out a little bit and just talk about the issue from CPJ's perspective. I think, as many of you know, we document press freedom violations around the world. We've been around for more than 3 decades, and we recently produced our first detailed report on the United States and the Obama administration's press freedom record. It was written by Len Downey and Sarah Rafsky, my colleague here. And what we were looking at, and what I really want to ask you about, is we're talking about this issue entirely within a domestic context, which is natural. We're talking about national policy. We're talking about the intersection of government and government oversight and the relationship between the media and the government, and as Bart put it, self-governance and the common defense. But I would ask the panelists to think about these issues from an international perspective. That's the perspective in which we look at it. What are the implications of a policy in which there's a perception in the United States among journalists and among certainly people in the legal profession that has been documented by the ACLU and Human Rights Watch, that their communication is being monitored? And that's had a profound impact on the way that people in those professions work in this country. And I would ask you to talk about, is there any consideration given to the impact of these policies outside of our borders, particularly on the media?
Bob, you want to take that first?
Well, yeah, certainly part of it. You know, back in the Nixon regime, President Nixon had an enemies list, and people were quite surprised. But then, very quickly, people in Washington were hoping they were on it, because it was a sign that they had the juice, and so on.
And because he'd already been hounded from office and no longer had the power to harm them.
No, this was all long prior. The enemies list was long prior to that. The notion that the intel agencies are interested in picking up conversations of press people, it's not an issue. If you're interviewing bin Laden, you're probably going to be picked up, and you should be. You absolutely should be.
But there's a lot of gray areas.
I understand there are gray areas, but simply, the press are not immune from the laws of the United States. They simply aren't immune. You know, if you don't like that state of affairs, try to get a press shield law, which has been suggested on many occasions and has been rejected. So, that is the legal regime under which we're operating. And, as they say, if you don't like it, vote your congressman out of office.
It's also, I mean, compared to what? This country, we have a Freedom of Information Act, we have the Presidential Records Act, we have the First Amendment. This remains the most open government in the history of the world. So I think those problems are real and should be addressed when they occur in those gray areas. But still, I think one should have some perspective. And I should comment on your report, which tried to show the crisis of American journalism that the Obama administration and following the Bush administration had created. I had a laugh while reading it at the complete absence of any understanding or any justification, even to answer why the government might be cracking down on leaks. There's not a sentence in that report that even gives a hint that there are problems with leaks that are dangerous.
We're short on time. I'm going to say 3 fast things. Sorry.
Go ahead.
One, in comparison to the plight of journalists in most parts of the world, we have it really good here. I can certainly agree to that. And I note that I am standing here on the stage and not in jail,
And you won a Pulitzer Prize.
And continuing to write stories and so on. Number two, the fact that the government has decided, and only in very recent years, with the sole exception of Ellsberg, to start charging sources with espionage for leaking to a reporter. They're describing it as espionage to talk to a reporter for a story for general publication that is intended to educate the entire American public. To treat that as espionage is a habit that has much less savory precedent around the world, and which enables the government to use all of its national security tools to unravel who the journalists are talking to, and it does. It does not routinely monitor journalists for sure, but when it wants to find out a source, because it classifies this as espionage, it can and does use those tools.
Any others with questions from the audience? In the back, there.
Thank you, Rory O'Connor from Global Vision. You know, Bart Gellman said that he rejects the idea that security and secrecy always coincide, which I think is really what we should be talking about here. And I would posit that all this post-9/11 secrecy, in fact, has made us far less secure. And there's many examples, but let's just take one, and I'd like you to respond to this. 2 investigations, as I'm sure you know, of 9/11, which is the event that kicked off this craze for secrecy over the past 13 years. And the joint congressional inquiry has 28 pages that outlines the Saudi Arabian role in 9/11. Still classified, no Americans have seen it. President Obama is on record as saying he will allow us to see it, yet 2014, we have no idea what is in those 28 pages.
I would be the first to agree that the government vastly overclassifies and that the press has a critical role in uncovering secrets. There's no quarrel about that.
I agree.
That's the way. That's the American system. That's
Go home now.
On that aspect, you're dead right. But I don't know, but I can easily hypothesize, as everybody in this room could hypothesize, why the U.S. government would not want certain aspects of the Saudi connection to terrorism revealed.
So can I, to cover their butts.
No, sorry.
Well, wait, very quickly on that, is it valid to classify because it might disrupt diplomatic relations
Absolutely.
or embarrass an ally?
Absolutely.
It is.
Of course it is.
There's a limit.
I mean, I think it's way too pat to go too far on either side of this. There are legitimate vital secrets. The very first story I did on the NSA documents was about the PRISM program, and I withheld lots and lots of information from that story that I didn't even ask the government about. I told the government everything between pages X and Y I'm not interested in writing about because it exposes very specific and productive operations that nearly anybody would support. I'm interested in the broader policy.
We actually have a member of the press in the audience who has a question, so I'm going to let the news media make an inquiry.
Thank you. I'd like to address this to, I guess you wouldn't call yourselves this, the anti-secrecy caucus on the panel. And that is, would you care to compare the Obama administration to previous administrations? Because we're constantly hearing that their prosecutions are more than all other administrations combined. You know, James Risen is threatened to go to jail for refusing to burn a source. So I'm just curious what you all, Isikoff, Gellman, Hina.
I'm the moderator, and so I'll take a pass, but Hina and Barton.
Pass?
You know, I think as a starting point, our history is such that, especially in times of real or perceived emergency, governments overstep on secrecy issues. And I think one way I think about this is the ways in which the Obama administration, after first starting out by making promises of greater transparency, lessening overclassification, providing greater protections for whistleblowers, limiting the use of state secrets privilege, has in fact turned its back and done virtually the same, if not similar things, to the Bush administration. I think there is a significant negative consequence that comes from the Bush administration's approach, which was largely to make arguments for overweening secrecy that resulted in less accountability and impunity for rights violations in the Obama administration, which has virtually guaranteed by continuing to make those arguments in a number of different contexts. And I think it does make a significant difference the extent to which there have been an accelerated number of prosecutions of leakers. You know, in some sense, we could have far, far more prosecutions of leakers given the number of leaks that take place every day, including at the highest levels of government. But instead, when we have prosecutions of leakers who reveal information that is likely to show wrongdoing or embarrass the government, then a particular message is being sent that I think does have a chilling, discouraging effect domestically, as we and Human Rights Watch have documented, and that does have a negative effect when you think about the scale of surveillance that can now be carried out at home and abroad.
I think we had one more question in the back, and that may be it. Yeah.
Thank you all for the presentation. My question is for Mr. Gellman. I'd like to know, as someone that has been with the Snowden story from the beginning, what has been the most surprising to you about the reaction and the way that it's played out both in the US and abroad?
Most surprising about the reaction? Well, one big surprise is that we're still having panels like this a year and a half almost after the story began. If he had asked me, you know, in the spring of 2013, if this would still be a kind of A-list global story with enormous amounts of debate and change still underway after more than a year, I would have said, forget it. It's one reason I'm glad I'm in the fact business and not in the prediction business. I'm usually wrong about stuff like that. I am moderately surprised that we had as much of a turn as we did in public opinion in the direction of thinking perhaps the steps that our government has been taking to protect us have gone too far. You would be hard-pressed to find a majority or a plurality for that on any subject after 9/11 until this one. And I suppose, I mean, well, there's lots of things I was surprised by substantively in terms of what the government was doing, but those would be my two top ones.
We actually do have time for one more. If anybody has one, then
Thank you. Thank you for a very good debate. I just wanted to remark, right before I came here, online CNN Money, the SEC is giving the largest whistleblower award, $130 million, to this unidentified woman not living in the U.S. They did not identify the company that she informed against, but the SEC said, in giving that award, we could not have done it without her. And I think it's ironic that Snowden is sitting in Russia, and we would know nothing if it were not for him.
Actually, could I respond?
Go right ahead.
It's actually not that ironic. That award is pursuant to a statute passed during the Civil War to try to prevent frauds against the government. I emphasize pursuant to a statute. B, we're not talking about national secrets. You know, most Americans value, I think, their safety. And there's a wonderful line by Justice Robert Jackson that the U.S. Constitution is not a suicide pact. And what he was getting at is that it is a mistake to overread legal technicalities in the face of practical problems. And I think that what NSA has done has shown that it lives within a regime. You may want to change that regime, great, do it. But bear in mind, you may pay a price.
Yeah, that's actually the whole point. If the NSA lives within a regime, you might want to change it, and we didn't have an opportunity to debate that until recently.
And on that note, I think we are out of time, so I want to thank our panelists for a very